Good evening and welcome to the Margaret McLean Show. Tonight we have breaking news in the Luigi Mangione case, a major departure in defense strategy. What is going on here tonight? We'll break it all down. I'm Margaret McLean, a former prosecutor, trial lawyer, and law professor. On this channel, we go beyond the headlines and translate what's actually happening inside the courtroom. And my goal is to help you understand how lawyers, judges, and juries evaluate evidence, make decisions, and navigate the complex legal issues that often get lost in the media coverage, and especially this one. So, Luigi Mangione is the man accused of gunning down UnitedHealthcare CEO Brian Thompson on a Manhattan sidewalk in December of 2024. Prosecutors have built a strong case on both the state and federal levels. They've got surveillance footage, writings allegedly linked to Mangione, the weapon, and other evidence linking him to the crimes. The big news yesterday was that attorneys notified the court that they intended to pursue an extreme emotional disturbance defense, which is a New York legal doctrine that could reduce a second-degree murder conviction to manslaughter if a jury buys into it. Well, I prepared for that case. I prepared all day, and guess what? They just informed the court that they are withdrawing that strategy. So it could have allowed a jury to convict Mangione of manslaughter rather than murder if the defense could prove he was acting under an extreme emotional disturbance at the time of the shooting. And according to his writings and all sorts of evidence, he was very upset with the insurance industry. He had chronic pain, and that's going back pain, and we'll discuss that. So why on earth would the defense team walk away from what I think appeared to be a viable plan to reducing a murder charge to manslaughter? Was the defense concerned about what the prosecutors would gain access to once Mangione's mental state became an issue? I don't know. Did newly unsealed records reveal weaknesses in the defense theory? Did the defense conclude that the risks outweighed the benefits? Or simply, did the defendant Mangione himself change his mind? And we know that defendants can sometimes do that. They flip-flop. Yeah, but could this signal a greater focus on challenging the prosecution's evidence rather than explaining Mangione's state of mind? It also comes as Mangione continues to fight on multiple legal fronts. He's pleaded not guilty in both the state and federal court. The state second-degree murder trial is expected to move forward, possibly in September. We've got a federal stalking case that follows after that. His attorneys have challenged the back-to-back prosecutions, arguing that they amount to double jeopardy. So we'll be talking about that as well. So far, courts have rejected that argument, citing the legal doctrine that allows both state and federal governments to prosecute the same conduct under certain circumstances. Mangione has pleaded not guilty, and I'm just shocked at what suddenly went on. I mean, why? And I'm just blown. Kind of my mind is blown on this sudden change of mind, because I thought that the defense was preparing to put the health insurance industry itself under the microscope in an effort to explain why his crime occurred, right? But I don't know. So joining me tonight to sort this out and to answer my questions as well as yours is New York attorney, a great attorney, Richard Schoenstein, and he's the host of the show, So Sue Me. And I strongly recommend you guys, if you're not subscribed to that show, subscribe to it, because you will learn something about the law. So Richard, I'm going to put you in here, and welcome to the Margaret McLean Show.
Great to be here.
Yeah.
Thank you, Margaret.
Absolutely. Thank you for coming. So Richard, I seem flustered because, of course, I prepared I'm like, my words are going all over the place here because I prepared for a different type of show with really different questions. Thank God I saw the breaking news, right? That would have been not good. But let's start with the big news here. How significant is it that Mangione's lawyers withdrew the extreme emotional disturbance defense after initially announcing it? Yeah, Wednesday.
Well, so the first thing I want to say is I think we have to consider whether they've really withdrawn the defense. Their notice that was picked up in the media, I'm looking at it now, says the defense respectfully withdraws CPL 250.10 notice at this time. That refers to the criminal procedure law in the state of New York. That notice was notice of a psychiatric expert witness.
Okay.
So what they withdrew was the notice that they would be putting on an expert psychiatric witness. It doesn't say we're not going to use an extreme emotional disturbance defense. It only says we're not going to use the expert psychiatric witness. Now, my understanding is the extreme emotional disturbance defense does not require expert testimony, although it is certainly helpful if you're going to put on a defense like that. It would certainly be better to have that kind of testimony and not, for example, the other way to do it is just have the defendant take the stand or people who know the defendant to say he seemed disturbed, but that doesn't, that's not going to persuade a jury ordinarily. So it may be, what I'm trying to say is I'm not sure we can conclusively say they are not doing the extreme emotional disturbance. The only thing we can conclusively say is at this point, they are not proffering an expert witness.
Why would they say that at this point?
Well, you'll recall that the reason this came up is because they had to give notice of the expert witness in advance under the law, under the procedure. And then they're required to produce discovery. They're required to give the prosecution access to that expert's reports and medical records. And by withdrawing the notice that they're going to use the expert, they no longer have to allow access to those records. So my assumption is they didn't want to produce the records. My assumption is they determined that the value of the expert was diminished by what they were going to have to produce. There's so many factors, Margaret, that go into that kind of determination. I can't really tell you exactly what their thinking was. I can only tell you what I think the factors are and kind of speculate how they got there.
Well, that's excellent, though. That what you pointed out already, that's what we talk about. We're breaking down the law instead of just looking at what the media is reporting. So I appreciate that. And that's what both of our shows do, actually. Yeah. So let's back up for a moment and explain to people that are just coming on what that defense was all about. And
Sure.
Why is it particular to New York?
Well, I don't think New York's the only state that has it, but New York does have it. So it's not an insanity defense, which is, I think, what most people think of when they hear this. Insanity is you're incapable of telling right from wrong. You can't be held accountable for your actions. And instead of going to prison, you should go into some sort of care for a serious condition. That's not what this is.
Right.
Extreme, and you should be found not guilty. Right. Extreme emotional disturbance is only used to reduce a murder charge to a manslaughter charge. Mm-hmm. If it's successful, it can take a murder charge, which has a potential life imprisonment sentence, and reduce it to a manslaughter charge that has between 5 and 25 years.
Right.
And so you can see how that would be attractive for a guy like Luigi Mangione, who's still very young.
Exactly. And I thought it made sense because if you look at his medical history, he suffers from chronic back pain. He's had a fusion surgery, and he had a surfing accident that also exacerbated it. So insurance, I did notice insurance paid for that surgery.
Yeah, I
So,
don't know. I don't know about the bona fides of his claim, but to prove extreme emotional disturbance, you have to show that first of all, it's a defense. It's the defendant's burden of proof. It's not the
yep.
prosecution's burden. It's the defendant's to prove that he had an extreme emotional disturbance, that there's an explanation or excuse for it, and that in committing the homicide, the defendant acted under the influence of the extreme emotional disturbance. And so when I heard yesterday that this defense was in play, and it wasn't yesterday that they announced it, they had given this notice secretly to the prosecution, and there had been court proceedings under seal. And the reason they were under seal is because you don't disclose this kind of thing to the public unless you're really going to do it, especially when there's a second federal prosecution going on.
Right.
So what I thought yesterday was, oh, they're going to put the insurance industry on trial.
Yeah.
Right. They're going to say he's emotionally disturbed because of what happened to him and his interaction with the insurance industry. And I didn't know the underlying facts, if they can show that, but I thought that's what they were going to do. And that would be sort of an invitation for the jury to intercede on his behalf, because they too hate the insurance industry.
Yeah. Yeah. And to prove the burden shifts to the defense to prove the affirmative defense by a preponderance of the evidence. So it's not beyond a reasonable doubt. I thought that, I started to think, he's got this long history. He can back it up. And you can make the argument, gee, this guy was so upset, in so much chronic pain, that it impacted his state of mind.
Yeah. And all true. But of course, to do that, you're essentially conceding he is the murderer.
Correct.
Right. You change it. I said yesterday, you change it from a who did it to a why did it. Why did he do it? And you can still, the prosecution has to go first, so you can still wait if they have proof beyond a reasonable doubt. But if you're going to stand up an opening argument and say you have an extreme emotional disturbance defense, you're basically telling the jury that he did it. So, and I could understand if you conclude as a defense lawyer, the evidence against him is insurmountable, especially with the way the court has ruled on all of these evidentiary issues. Right. I can't contest who did it. I'm going to lose that. So all I'm going to do is try to soften the penalty as much as possible. My job becomes not get him off, but get him out eventually.
Yeah. And hypothetically, if it was reduced from second-degree murder to manslaughter, what would the sentence likely be for that?
Well, manslaughter is generally up to 25 years. And with a possibility of parole, so you could actually be out of jail substantially before that, depending on the circumstances. But if you think about it, he's 28 now. Is that right?
Yeah, well, I think so. He's in his 20s. That's young to me.
So right, that's young to me too. So you change it from life in prison to he could be out in his 50s. And
I know it.
So that and when you think about the defense in this case, they already have removed the death penalty from the equation. Yeah. And in the New York State case, they got it reduced to second-degree murder, which carries a possibility of parole, even if it's a life sentence. So his defense team has already softened the possible penalty in this case.
Right.
And the manslaughter, converting it to a manslaughter conviction would really go a long way. But, you're essentially conceding guilt.
Right. And maybe, so the federal trial is going to follow the state trial.
Right.
So how would if they went with that strategy of the affirmative defense with them trying to reduce to manslaughter, how would that impact the stalking charge in the federal level?
Well, here's a problem for the defense. The federal law doesn't have the extreme emotional disturbance defense. So they can't use it in the federal case. And, presumably, if he testified, let's say, for example, but you don't have to put on the defendant to testify for this defense. It's not like self-defense.
Right.
But let's say he testified and talked about his own emotional disturbance and conceded guilt. The prosecution in the federal case could use that. If we get to a second trial, and I don't know, after the state trial, I don't really know how double jeopardy is going to sort out. I don't really know if we're going to get to a second trial, but if you did, there's a potential problem there.
Yeah, explain what you mean by that.
What, by the double jeopardy part?
Yeah. I thought you did a great show on that, by the way. I watched that. And I thought your explanation was so good. I was like, oh, explain that on my show.
That. So you can't try somebody twice for the same crime. That is a constitutional protection, and we call it double jeopardy. Now, people say, well, he's being prosecuted by the state and the federal government at the same time. Isn't that double jeopardy? No, that happens all the time. Jeopardy doesn't attach until a jury is sworn in. So he hasn't had single jeopardy yet, and therefore can't have double jeopardy. But if the state case proceeds and a jury is sworn in, then jeopardy attaches in the first instance. And the theory is you can't try him again in a federal court, especially imagine if he's found innocent by a jury in the state case. Let's say they come back and find him innocent. And then you would argue you can't let him be tried essentially for the same thing in federal court, even though it's a federal crime versus a state crime. And I have never sorted through all of the double jeopardy issues because there's so many variables. What does he go to trial for? What does the jury decide? What's the result of the first trial? What's he going to the second trial for? But once he goes to trial in the state case, there is a live argument that a second trial would be double jeopardy. And we would have to see how it sorts out. Yeah. So, but if they can get past that, if they get to a second trial, then the extreme emotional disturbance thing could hurt him in the second trial. Right.
So if in fact the defense abandons the extreme emotional disturbance claim, do you think it's because of the federal? Do you think it's too risky? They maybe examined it?
Well, that's why I said there's really a variety of factors here. And I don't know which ones are. So one problem is the federal case. One problem is using it in the state case and having the federal case facing you. Another problem is what I just said, that you're essentially conceding guilt. And, you have 12 jurors. The prosecution has the burden of proof beyond a reasonable doubt. Do you want to concede guilt? Or do you want to argue reasonable doubt? Like, I thought they were going to argue reasonable doubt,
Right.
There's a reasonable doubt. You can't tell from the video it was him. The fact that he was in New York is not proof of anything. I know there's incriminating evidence in the bag, but that could have been planted, or maybe it's not his. It's a hard argument to make.
Yeah.
But and also they're going to appeal the admissibility of all of that stuff down the road, right? They have an appeal on that.
Right.
I don't think it's a successful appeal, but they have an appeal. But if you think, and then work into that, this notion of jury nullification. the notion that somebody is going to get on that jury who is one of these Mangione's supporters and is going to vote not guilty no matter what. So if you
Right.
think that's going to happen, do you want to go to trial and concede he did it?
Right. And maybe you're right, because maybe a juror might be so strong-minded and they'd probably be a hung jury, but maybe somebody so strong-minded would convince the others to give him a not guilty under the concept of jury nullification. You would be abandoning that. You're right.
And I thought it was a weird thing to say to his fan base.
Yes.
So he is a fan base of people who assume he did it and support him in having shot somebody to death. And now you're telling the fan base, well, no, he's not a hero. He was extremely emotionally disturbed.
I could see the fan base buying into that, though.
Sure, I do. I guess the fan base could say, right, the reason is because of the insurance industry.
Mm-hmm.
That is how you reconcile those positions. But I also, I don't know what their psychiatric expert was going to say. The problem with extreme emotional disturbance is I think most of the time it arises in heat of the moment kind of cases.
Mm-hmm.
Heat of the moment, like you walked in and your wife was in bed with a guy and you shot him, right? Because you were extremely emotionally disturbed. If the evidence accurately reflects what happened here, there's a lot of planning.
Oh, yeah. Oh, for sure. There's a lot of planning, but it's interesting, the concept of chronic pain. Somebody who, if he really did suffer chronic pain like that, it can affect someone mentally. So that's what I thought they were going with that. But you're right. It doesn't make sense, because stalking, he could get life for that in the federally, right?
Yeah.
Yeah.
Yes.
So,
well, chronic pain can make you, but you have to plan it. You have to travel to New York. You have to secure the weapon. You have to plan your egress. It's not really what you think of when you think of an extreme emotional disturbance case. You really think of somebody who suddenly snapped because they were disturbed. Once you put planning into it, it's very hard. The planning aspect really hurts any kind of insanity, emotional disturbance. It hurts a self-defense case, right? Whenever you get into planning.
Right. That's true. That's true. And how do you think the defense team has performed so far?
So I think the defense team has thus far performed brilliantly. They have a very high-profile client who the vast majority of people assume is guilty. I know he has supporters, but I think they are a loud minority. I think the vast number of people, and they've fought for his constitutional rights. They've stood up when he was brought to New York and put in some kind of campaign ad perp walk by Mayor Adams, which was ridiculous. They made noise about that. As we said, they got rid of the death penalty claims and they got rid of the terrorism claims in New York. And those were big, big victories by the defense. They did successfully preclude some of the evidence in the backpack, although the most important evidence in the backpack is coming in. But they did have some success. And I just think and I know some of those lawyers. I mean, those are good lawyers. Those are in-demand criminal defense lawyers in New York City. They know what they're doing. They're doing a good job. And that's part of why I don't want to second guess them on strategy here.
Right.
There are so many considerations. I don't know if letting this expert go is good or not. I assume they considered what his report was going to say and what he was going to, or he or she was going to say in testimony, what kind of witness they were going to be. I assume they considered everything and decided to back away from it.
Okay, I guess the question I have is, why could they have waited to decide to back away from that? Why not
No,
wait until the eve of trial?
they were under a deadline.
Okay.
Remember, the
okay.
trial is supposed to start in 3 months.
I know.
They were under a deadline. They had given notice under CPL 250.10, and they were under a court deadline. The deadline was today to produce the medical records. So the reason they gave notice, they withdrew their notice, is so they didn't have to produce the medical records.
Right.
Which suggests to me they didn't want to produce the medical records.
And the strategy behind not wanting to produce those medical records, maybe they didn't want the prosecution to see what was in there. I mean, what would?
Yeah, possibly. Yeah. Possibly. Okay. I mean, if he's talking to a psychiatrist, he might have confessed.
Yep.
That could be in the medical record, right? Yeah. The medical record of an expert who's going to testify that he did it because he was under extreme emotional disturbance is theoretically going to say that he did it.
Right.
So you don't want to produce that unless you're absolutely sure you're going to use it and it's the right strategy.
Okay.
And you know what? If I was going to, the question I would have for the defense is, why let it go this far that the decision was made the final day the expert evidence was due? And we had this big reveal yesterday in court that they might be going down this path. If they had done this yesterday, it all would have remained under seal.
Right.
And we wouldn't know necessarily that they had a psychiatric witness, that they were contemplating this defense. We might not know any of that if they had withdrawn it before the hearing yesterday. So if I could talk to them and they would never answer a question, especially in the middle of trial. But that would be the question is, why did that happen today instead of before yesterday?
Yeah. Yeah. And that's interesting. Do you think it could have been planned, a strategic plan to get something out in the media? I mean,
I don't think it was advantageous to them in the media. I mean, if you want rank speculation at its finest, I could tell you they might have, they might have thought it was helpful to a plea negotiation.
Okay.
I don't know if they're having a plea negotiation. I don't know where any of that stands. But if they wanted to say to the prosecution, hey, here's how we're going to get him out of a life sentence, so let's have a plea negotiation at something less than a life sentence, it could have been a strategy for that, but I don't know that it was.
Right. I can't imagine the prosecution offering any plea deals on this. Can you?
No.
Yeah. What about on the federal level?
Not the federal level one. The federal government wants to kill them. So no, they're not offering anything. I mean, the federal government's involvement in this case is ridiculous. We just had the sentencing of Rex Heuermann. I'm sure you followed that one.
Oh, too. Yes.
Yep. So Rex Heuermann easily could have been prosecuted by the federal government, but he just murdered 8 women. And the federal government doesn't care about 8 women. They care about one male healthcare executive. They really care about a male healthcare executive, but they don't care about 8, under the radar women who were murdered. So they weren't present in the Heuermann case. I do think, I think federal law enforcement was involved in the Heuermann case and was helpful, but they didn't prosecute.
Right. Yeah, that's an interesting way of looking at it. So it really becomes political between the feds and the New
Right. Where was the
York
federal
State.
government
Yeah,
in the Idaho case, right? The Koberger case. That's another defendant
right.
who crossed state lines to commit a murder. And if you want to talk about stalking, right, that is a
Yeah,
stalking case. Federal government easily could have prosecuted in Idaho. They don't care about college students. They care about a male healthcare executive. So it is
right.
political. It's very political. And so
Yeah,
the federal government will, I don't think, will negotiate.
no, you're right. Well, they were going for the death penalty. So, yeah, but so I guess maybe the difference would be under Idaho law, on the state level, you can get the death penalty. So here in Massachusetts, we don't have the death penalty, but under federal law, and the feds have prosecuted cases here so that they could get the death penalty for different people.
Yeah, I appreciate that difference in Idaho, although but they didn't prosecute Hewerman in New York. They
Yeah,
didn't come in, they didn't seek the death penalty for Rex Hewerman in New York, who murdered 9 women.
I know that doesn't make sense.
Right. It doesn't make sense. It doesn't make sense. It is, and the other thing that has really bothered me about the Mangione case is it's very clear that the prosecutions aren't cooperating. Right. In fact,
Oh yeah,
they were in some sort of race to see who could get to trial first.
yep,
Instead of, you're supposed to say, if you have a mutual goal, which is to convict someone you think committed a heinous crime.
right,
So you're supposed to sit down, cooperate, and figure out how best to accomplish that. You're not supposed to be each off in your own corner trying to race to the end. And I think it's really hurt the case. I think that's hurt the case. I think the overcharging in both prosecutions has hurt the case. Seeking the death penalty, arguing terrorism, all of that I think has hurt the case. It's a straightforward case based on what I've heard about the evidence. It's as straightforward a case as you can have. Why muck it up with terrorism?
You're right. Yeah, it's very interesting, the political climate in New York right now, as far as the different the feds and the state. So that we'll have to follow that, because I also noticed on your show you talked about that as well, and I thought that was excellent. Yeah, people subscribe to the show. It's so good. I really liked your show, Richard. So, what else do you think? What else do you think we'll see on the horizon as we approach trial in this case?
Well, the other big issue that's out there right now is jury selection, because right, either the state or the federal case. So the state case is supposed to pick a jury in September, and one of the things they're working on is their questionnaire. And both sides have to be concerned not to have jurors on that have already made up their mind.
Right.
And we tend to think about this, we talk about this jury nullification. We don't want jurors on who are going to find him not guilty no matter what. But also, we don't want jurors on who are going to find him guilty no matter what. And defendants always have the problem of there are jurors out there who assume if the police arrested you, you're guilty.
Right.
You have to weed through and make sure you don't have any of those jurors. If you're a defendant, you have to make sure that the jurors are going to listen to the evidence and they're going to listen to the judge's instruction. In this particular case, the prosecution is concerned that there are going to be jurors who say you're innocent no matter what. And that's a challenge. I think they'll be able to do it, but it's a challenge.
I think it is tough. I mean, we've seen a little of that here in Massachusetts. I think it came up in the Karen Reed trial, at least the second trial. There was talk of jury nullification there. But it's interesting because I see that his, GoFundMe raised over $1 million, almost $1.5 million for his defense.
It's got $1.5 million. It's got 40,000 contributions, which, by the way, aren't all from New York eligible jurors, right?
True.
So some portion of them are, but there's 8.5 million people in New York City. 40,000 is actually not that big a percentage of 8.5 million. Even if
True.
it was 40,000, and it's not really 40,000 because they're not all from New York. So, but he has some support, and I think you're right to compare it to Karen Reed. I think they must have been concerned. The prosecution must have been concerned with all the public outrage in Massachusetts. They would have jurors there who had already made up their minds.
Mm-hmm. And here in Massachusetts, I can't go anywhere. Because I did comment on the case quite a bit, but just this past weekend, trying to go to Cape Cod, and people are still talking about it, and they will come up with facts that weren't even in, or that were debunked, and things like that. So it's still crazy here.
Yeah. Well,
and we have 4 lawsuits too.
Yeah. Right. I was going to say it's in civil litigation, so it's
yeah.
in my territory now. I really like it. But
oh, good. We can talk about that. I did some civil work too, so that would be fun to talk about the civil litigation aspect of that. I guess that's another night. But yeah,
we can get into that. But so they've got to go through this jury selection process, and I think that every juror is going to end up filling out a pretty extensive questionnaire. I think they'll be questioned in court by the parties, and I would imagine that both sides will be in the back of the courtroom vetting the social media of every prospective juror.
What do you feel? How do you feel about cameras not being in the courtroom for this?
Oh, I hate it. I mean, I think it's. I am a big believer in cameras in the courtroom, now more than ever, really, because there is some public mistrust of judicial proceedings, and because defendants now routinely say that the judicial proceedings were unfair in some way. Anybody who loses say they're unfair, right? So Alex Jones, by way of example, our president, by way of example.
Yep.
And when the proceedings aren't available for public viewing, I think it feeds into that narrative that they're somehow unfair.
Right.
I don't really know of any downside. And actually, the Mangione case is a pretty good example. Sometimes people argue that putting cases on TV poisons the jury well. How could there possibly be more coverage of Luigi Mangione than there already is? There's going to be coverage of that trial, whether there are cameras in the court or not. There's going to be a flood of reporters down there. And what they do is they just sit in the courtroom, and I have ones that I follow because I trust their reporting, and they, live tweet what's happening in the court. Mm-hmm. So if you're going to have that, why not just have a camera?
That's true. That's true. And then it would be nice for us to be able to, instead of having to get the information from someone in the media who's reporting back to us, it'd be nice for us to watch a proceeding and talk about it as 2 lawyers too.
That's right. And from my standpoint, as someone who does some commentary on these kind of things, I really would much prefer to see the question and answering rather than read it. Reading it and seeing it are 2 different things.
Exactly.
So I totally believe there should be cameras in the court, except where there is some specific reason, like a case involving a minor, some specific reason not to.
Right. Okay. Yeah. I was basically around for the Karen Reed case, and sometimes it does become quite a media circus, and sometimes attorneys play up to the media, but I think you're right in saying that it's going to be a media circus anyway. How hard is it for us to get into that courtroom, like normal people?
I don't know. I considered going down there this week to the hearing, and I was under the impression that I could have gotten in, that the courtroom wasn't full. I imagine when his case goes to trial, that courtroom will be full. And there'll be a line outside, probably starting early in the morning. I mean, it won't be. I went down to the Knicks parade today, and
Good for you.
it won't be a line like that.
No.
But
New York must be thrilled.
yeah,
I'm happy for the city. I really am.
Yeah, we're pretty ecstatic. I appreciate that.
That's great.
It's good, and the people are. There's a very good vibe in the city right now.
I wish I was there.
Yeah.
I'll be
But
there
to
soon
your
enough.
question, the courtroom will be full for his trial, and there'll be a line outside. And I don't know how that specific court will handle it. I mean, the Karen Reed case, there was a line every day, as I understood it, and there were fights in the line, and there was people place saving, and there was all sorts of controversy about it.
Yes. The problem with the Karen Reed trial, the second trial, they had it in the smaller courtroom. Both trials were in the smaller courtroom, and it was very hard to get a seat in that courtroom. Now, I covered the Whitey Bulger trial here in Boston, and they didn't have cameras in the courtroom for that. But what they did do was they had multiple overflow rooms. So if you went to the courthouse and you wanted to watch the trial, like let's say we want to see what the legal argument is going to be, people would go into one of the overflow rooms, which was fine. It would be closed circuit TV. So it was the next best thing. Are they going to have that?
I don't know. I don't know if the court's going to set up overflow rooms. That's a good question.
That would be nice, because then, we could watch it and comment after. That would be, but we'll see, won't we?
Yeah.
Well, thank you very, very much for coming on the show. I appreciate all of your insight. And for all my listeners out there, please tune in to Richard Schoenstein. He's the host of So Sue Me. I love the title too, So Sue Me. And it's a big discussion on civil law, but also you cover a lot of criminal cases.
Yeah, I keep saying it's about civil litigation, but then I can't stop talking about Mangione or Karen Reed.
I know.
Or Rex Heuermann. I'm like,
so you know what? What you say to that is, so sue me.
Exactly. Well, you don't have to listen. But I do
exactly.
try.
But you can sue me. So sue me.
I do try to talk about civil litigation because I think people are interested in that, and it gets a lot less coverage than the criminal cases, unless you have Johnny Depp in the civil case. It doesn't get a lot of coverage.
Oh yeah. Well, as one of the comments, of course, I always have to put my glasses on to read the comments, but one of the comments said they'd love to hear both of us talk about the Karen Reed civil proceedings. So we'll have to do that in the future.
Sounds good.
All right. Well, thank you so much, and have a wonderful rest of your evening, and bask in your glory of the Knicks win.
Will do.